Our theme, as you know, is European and American models of religious freedom, in particular the future of religious autonomy. While the focus in the field of freedom of religion or belief is often on individual conference, the history of protection of the autonomy of religious institutions is actually older. Even in the United States, the strand of autonomy jurisprudence goes back farther in our case law than free exercise jurisprudence. The early history of religious liberty is about emancipation of religious communities and their institutions from state control. From a comparative perspective, United States and European systems are often contrasted because of the absence of an establishment clause in the Constitution of European countries and within the European Convention for the Protection of Human Rights and Fundamental Freedoms. There is convergence on both sides of the Atlantic, however, in the importance accorded to the autonomy of religious institutions. One of the things that our non-establishment principle does is protect separation of religion and the state, which protects the autonomy of religious institutions. And by the same token, the autonomy principle in Europe protects distinctions between state and religious power. So on both sides of the Atlantic, we've had recent cases involving the principles of religious autonomy and the interaction of religious communities with their personnel. And it is our privilege, in a way, to have some very distinguished experts on this. We're sad to announce that Doug Laycock cannot be with us today. He had suffered a detached retina a couple of days ago and is under doctor's orders to lay low. He thinks this may be over after about 48 hours, and he may be able to be with us at a dinner this evening. But nonetheless, we have very distinguished representatives. Many of you would know that when the Hosanna Tabor case was being argued last fall, Doug Laycock was the lead counsel. He was working with the Becket Fund, and Kyle Duncan, who is the general counsel for the Becket Fund, is standing in for Doug this morning. We also have Professor Leslie Griffin, author of one of the leading case books on law and religion in America, and one of the leading exponents of the position that did not get accepted by the Supreme Court. But I still hold on. But you still hold on, yes. Even Supreme Courts can make mistakes. They can be right too. So, but that's part of the discussion today. We'll be hearing first from them, and then from Carolyn Evans. She is the dean of the Melbourne Law School in Australia, but those of us working in the field know her as the author of one of the premier books on religion in the European Court of Human Rights, and she's authored many other things in this area. And then Gerhard, who is at Trier, one of the leading experts in Germany on church-state issues in general and the autonomy issue in particular. He represented that there have been a raft of about 6 cases in Germany in the European Court over the past 2 or 3 years, and he represented about half of the churches in those cases, or at least. So we have a very distinguished group. Let me follow Tom's example and just let you share with you the questions that we gave to the panelists in advance. Again, not to require them to address these in any particular order, and recognizing that they have their own expertise and take on the issues, but just to have a kind of common starting point. So first question, with respect to the European nations or the US, to what extent do the US and European models differ on issues of institutional autonomy of religious organizations? How would you characterize how these models' conceptions of autonomy and their differences, if any, discuss the grounding of autonomy concepts? To what extent do conceptions of religious autonomy reflect notions of the role of religion in society? And then how are conceptions of religious autonomy reconciled with egalitarian norms and competing rights claims? what challenges are being brought and will likely arise in the future to protections of religious autonomy. So with that, let me turn to our panel, and we'll hear first from Kyle Duncan.
Thank you, Cole. It is a pleasure to be here, and it is a special pleasure to impersonate Doug Laycock in front of you all. Grateful to be here. What I propose to talk about is how religious autonomy is protected under the United States Constitution, and I'd like to focus on the Hosanna-Tabor decision, which was a recent unanimous decision by the Supreme Court recognizing a robust ministerial exception. If I have time, I'm only going to take 10 minutes. If I have time, I'd like to distinguish that line of free exercise and establishment clause cases, which protects institutional autonomy, from the Smith line of cases, which deals with individual claims of conscience in quite a different way. In Hosanna-Tabor, the Supreme Court unanimously recognized what the courts of appeals had unanimously recognized for over 40 years, which is that there must be, and is, some form of exception protected by the religion clauses of the Constitution with respect to religious organizations' decisions about who to hire and who to fire as a minister, within quotes. So the first thing is to note what the court held, which is, and this is one of those rare decisions, this is a rare unanimous decision, perhaps evidence of miracles, that the Supreme Court was able to unanimously get all 9 justices on board for this extremely important principle, which the Supreme Court had never directly addressed before. So here's what the Supreme Court said about this. It said, quote, "Both religion clauses bar the government from interfering with the decision of a religious group to fire one of its ministers. The Establishment Clause prevents the government from appointing ministers, and the Free Exercise Clause prevents it from interfering with the freedom of religious groups to select their own." Now, first thing to note about that is the court is asking both clauses of the first, both religion clauses of the First Amendment to do work. We see in many cases where these clauses are portrayed as fighting against each other. Here, in this case, the clauses are working in tandem to protect the autonomy of religious groups. Now, you can read the opinion. The court goes through a historical background all the way back to Magna Carta, to Henry VIII's Acts of Supremacy and Uniformity, essentially with the propensity of the English kings to interfere with filling of ecclesiastical offices. And the court recognized that the First Amendment was adopted against a background, in reaction against a background where colonists were afraid that government would interfere with the filling of ecclesiastical offices. So we get some sort of historical examples, such as James Madison, while Secretary of State, saying to Archbishop Carroll, or Bishop Carroll, the Catholic Church, look, the federal government is not going to weigh in on who should represent the Catholic Church in federal territories. We just don't do that here. That's why we have an Establishment Clause. So what about the jurisprudential background of this decision? This is something Cole alluded to, that church autonomy is not something the court made up in Hosanna-Tabor, that it goes way back. Now, the court had not had a chance to address the issue of hiring and firing ministers, per se, but in a series of decisions going back as far as 1872, the court had dealt with disputes involving church property or church hierarchy, and the court had consistently said the federal courts don't get involved in these kinds of disputes. And why? It's not only to protect the institutional integrity and autonomy of the religious organizations themselves, but it's also to prevent the government from intruding into ecclesiastical decisions. So you have a case like Watson v. Jones, you have a case like Kedroff from the 50s, and Milivojevic, I'm sure I've mispronounced that, regarding the refusal of civil courts, or the fact that civil courts in the United States are barred by the Establishment Clause from interfering in ecclesiastical decisions. Those cases involving church property disputes. You even have the court in the Kedroff case in 1952 speaking of the free exercise of an ecclesiastical right. The free exercise of an ecclesiastical right. So the principle of autonomy, of religious group autonomy, is there. And what it took for the court in Hosanna-Tabor was to say, well, how does that require us to recognize some form of exception for religious groups' decisions about who is going to occupy important roles in their organizations. And the court unanimously said yes. And here's what the court said with respect to the ministerial exception. Requiring a church to accept or retain an unwanted minister or punishing a church for failing to do so interferes with the internal governance of a church. By imposing an unwanted minister, the state infringes the free exercise clause. According the state, the power to determine which individuals will minister also violates the establishment clause. So there you have the two clauses working in tandem as a dual protection, a protection for group autonomy for the religious groups, but also a shield against government interference in ecclesiastical matters. So the way I like to think of this is here we have a true separation of church and state, not the ersatz separation of church and state problems represented by creches and menorahs and talking wishing wells on in City Hall around Christmas time. These are very interesting and fun for law students, but they don't represent real, in my view, they don't represent real sharp questions of the separation of church and state that go back in history and then actually menace people's rights. Right here, however, you really do have that. You have the specter of the government coming in and weighing in on theological, ecclesiastical decision-making. What about the right of association? What did the Supreme Court say about that? Because groups, after all, whether they be secular or religious, do have rights of expressive association that have been recognized by the Supreme Court in numerous cases. Why isn't that enough to protect this sort of ministerial hiring and firing decision? Well, the court, now this answer didn't satisfy everyone, of course, but the court said, quote, the text of the First Amendment gives special solicitude to the rights of religious organizations. The text of the First Amendment. So now we know that all 9 justices of the Supreme Court are textualists. What about, now I'll talk about Smith in a second, because the court has a cryptic paragraph about distinguishing the Smith decision. I'm sure that Professor Griffin will get into that, and maybe I'll be able to respond to questions on that. But let's bracket that for a second. What about this other objection? Why can't we allow courts to weigh whether a church who has fired a minister has done so on pretextual reasons? Of saying, well, look, we had a religious reason to fire this person, but the real reason was X, Y, and Z. Why can't a church probe into that, do a pretext inquiry? And the court, again unanimously, said no. Allowing that sort of inquiry, which is common in employment discrimination suits, would really defeat the whole purpose of the ministerial exception itself. It would ultimately and inevitably require courts to say, what was the real reason? Was it the religious reason, such as in Hosanna Tabor, the failure to follow the internal church resolution processes? Or is it some other nefarious reason? Are we going to allow civil courts to get into that? And the court unanimously said, no, we're not going to do that. And in concurrence, Justice Alito, joined by Justice Kagan, and it'll be interesting to see the next time Justices Alito and Kagan join in a concurrence together, elaborated on this point and said, if you allow a pretext inquiry, you're going to have a judge or a jury weighing the importance of a particular religious doctrine. So say the jury will say, well, look, the Lutherans said they had this internal dispute resolution. That doesn't sound very important. They probably had a pretext for firing the person. If you allow a decision maker to get into that realm, Justice Kagan and Alito said, the mere adjudication of such questions would pose grave problems for religious autonomy. So let me leave it there, and respecting the time limits here. That's a sort of a nutshell into this ministerial exception. The other areas I hope we get into, and I'm sure we will, is that consistent with the Smith line of decisions? And also, how broad is this ministerial exception? Is this going to prevent tort suits against churches for something a minister does, something clergy does? Is it going to prohibit a breach of contract lawsuit against a church? Is it going to prohibit the enforcement of criminal laws against a church? And we can talk about that. And the Supreme Court said, of course, we're not dealing with any of that right now. We're dealing with employment discrimination suits. So in sum, that is sort of the signal announcement from a unanimous Supreme Court on whether there is a ministerial exception implicit in the religion clauses of the Constitution, and the court gave us the resounding yes for an answer.
Thank you. Professor Griffin.
Okay, good morning, everybody. Thanks to Georgetown and BYU for sponsoring this conference and to all of you for attending this morning. And in the United States, this theory of church or religious autonomy is on a collision course with liberty and equality. And the reason for that is something that Kyle just mentioned, right? It puts this tremendous emphasis on institutions and the power of institutions. And who suffers when institutions gain more power is the individuals working within those institutions. And I think that emphasizing the institutional aspect of religious autonomy neglects the idea that under the Establishment Clause and under, say, both European and American history, we should be suspicious of the power of churches as well as of state, and when the two of them combine to keep individuals out of court, individual liberty suffers. Now, in the ministerial exception area, I congratulate Kyle and Doug, who's not here, right? A unanimous victory in the Supreme Court is a great thing. Unfortunately, I think the court lost sight of what it did when it created a ministerial exception, right? It sounds like a good thing. The government can't interfere in ministers, but who counts as a minister and what laws are at stake puts a huge number of people outside the protection of our anti-discrimination laws. If you think that the Hosanna Tabor itself was about disabilities discrimination, of course there are numerous age, pay, race, gender discrimination cases that the courts have repeatedly tossed out under the ministerial exception. And that's why I say equality is at stake, right? Do we really think that religious institutions, right, and not just pure churches, right? When we talked in the first panel about the expansion of religious institutions into welfare work, right? Religious hospitals, religious universities, religious schools, that none of those should be subject to the anti-discrimination laws is something that proponents of individual equality have to worry about, right? If you take a big swath of employers outside the protection of the anti-discrimination laws, you place fundamental values at stake. And I suggest that religious liberty for institutions shouldn't always win those disputes. So the ministerial exception has already in the lower courts, and now, because of the Supreme Court, threatens to harm a lot of individuals at religious institutions. And minister, it's right, it sounds good, minister, could be a narrow term. Of course, everybody knows here at Georgetown that, for example, there are no, well, we won't say there are no, but the Catholic Church doesn't recognize women as Catholic priests. Nonetheless, all the women employees in religion cases, right, the school principals, the school teachers, and so forth, have all been deemed ministers for the purpose of the ministerial exception. And in a recent case applying Hosanna Tabor, a Kentucky appeals court said that a Jewish professor of Jewish studies teaching Jewish studies at a Disciples of Christ seminary was a minister for purposes of the ministerial exception because he taught at a seminary. And the dissent said it was a very disturbing situation to think that a Jewish professor had become a minister of Jesus Christ. And so, as I say, I think the worry about a unanimous Supreme Court decision, right, is that people can pick it up and run with it. And it seems to me one additional place where people are running with the theory of institutional autonomy is, of course, in the current debate about contraception. And so if we say, well, religious institutions should enjoy religious autonomy from the healthcare laws, then the assumption now, right, and I can tell you on my losing side of it, right, it's a hard idea to sound like you're against religious freedom, right, and so that's why I think, well, the assumption has been, oh, these religious institutions, they shouldn't have to follow the contraceptive laws, right, it's a burden on their religious freedom. But emphasizing the institutions loses track of the individual employees again, right? Both the employees of the same religion who might want to exercise their reproductive rights and the secular employees, right? Since in many of these institutions there are secular employees. And so the religious institution theory, if it really, right, and all those cases are now going to be litigated. We've got not only hospitals and schools, but we now have some commercial businesses run by Christian employers who are all saying, oh, we have freedom, we have religious freedom not to provide contraceptive insurance to our employees. But there again, right, when I tell you the theory of religious institutional autonomy is at odds with individual equality and liberty. And so I worry that this trend toward protecting institutions will forget the rights of individuals, whom I would argue the Bill of Rights is really supposed to protect. So I look forward to good questions and comments. Thank you.
All right. Carolyn?
Well, thank you, and my thanks also to the organisers. It's a great pleasure to be back in Washington, D.C., where I lived for a few months 2 years ago, and such beautiful weather as well. Now, as someone from a third continent from the two that we're discussing today, and someone who's written and thought a little bit about each, I'm going to do something of a comparison. But given the limited time and the complex systems that we're dealing with, I'm painting with a very broad brush indeed, and fully expect to be pulled up on it during question time. I think there's always a danger of talking about Europe in particular as some coherent, unified identity rather than a collection of really sometimes extraordinarily disparate nations with their own history, culture, political background, to do with religion and also to do with other things that impinge on this question. So I'm going to talk a little bit about the European Court of Human Rights and a case called the Schuth case, which is always a danger. I'm going to talk about Hosanna Tabor, which Carl was very much associated, and the Schuth case, in which Gerhard was also a very important part. So again, I fully expect to be pulled up if need be. The Schuth case dealt with an organist, so somebody who was very involved in the life of a particular church, who had a child out of wedlock and was terminated from his employment because of that. That's to state it very briefly. This was upheld in Germany by the domestic courts, partly as a manifestation of the right of religious autonomy in the German constitutional structure, but was held by the European Court of Human Rights not to have paid sufficient attention to the sort of balancing of rights act that Leslie was talking about. Now, the broad thrust of my argument is that in both the US and Europe, there have been increasing challenges to religious autonomy. And I'll focus on the significant example of control over employment of people by religious organisations. But in the US, I think autonomy is still given a comparatively higher degree of protection than it is in Europe. And the reasons for this are partly legal and constitutional, but I think they're also partly historical and cultural. And in particular reflect the shift away from organised religion that exists in both continents, but is more marked in Europe than the US. So let me talk across two broad axes. The first is the question of from whom do we need protection, or to put it another way, in whom do we trust? The second is whether religious groups are properly seen as distinctive in a substantial or meaningful way from other groups of people who come together for particular purposes. So to the first question, essentially one of trust. The focus in a lot of US civil liberties talk, not just in this area but more generally, is about protecting the individual from the tyrannical, overreaching government. So in the sort of broad historical narrative that's often spoken, the constitutional moment here is one of throwing off an oppressive colonial government. And part of the constitution-making process is to try and ensure that Americans are not now subject to their own tyrannical government, their own monarchical president. So the popular narrative of the American story is of a people who value religion and who come here in part to freely practice their religion, and who then fight off oppressive government, put in place a constitutional system that protects people from such religion. Religions in this story effectively keep themselves nice. Now there's quite another historical story that could be told as well, but it's the state that's the threat to liberty. And indeed, of course, the First Amendment refers to restrictions on the power of the state rather than necessarily individual liberty. And Hosanna Tabor, I think, reflects this historical narrative in a more sophisticated and nuanced way than perhaps the popular membership. The court says that the members of a religious group put their faith in the hands of their ministers. Requiring a church to accept or retain an unwanted minister intrudes on more than a mere employment decision. It interferes with the governance of the church. And as it's a similar quote to one that Carl was using before, this means that the government is intruding where the government should not intrude. So the role of government in protecting liberty in this story is an essentially negative one. We have a fair degree of faith in churches as institutions. They're voluntary arrangements. The members of churches put their faith in the institution. The government is the problem. In Europe, by contrast, there's a far more active role seen for government. The European Convention on Human Rights is, of course, a treaty created by governments, not we the people, but by governments, and the primary obligation for the protection of a range of human rights is on governments. That role is more active and acknowledges that oppression of individual rights and liberties certainly can come from the state, but can also come from a range of other sources, corporate, religious, unions, and so on. The state has a legitimate role in finding a balance between the competing rights and interests. So in the Schuth case, for example, religious autonomy came into conflict with the right to privacy protected in Article 8, the right to family life. And in that case, the court says that it observes, though the object of Article 8 is essentially that of protecting the individual against arbitrary interference by public authorities, it does not merely compel the state to abstain from such interference. In addition to this primarily negative undertaking, there may be positive obligations inherent in an effective respect for private life. And those obligations may require the state to take on certain measures. In particular, in this instance, regard must be had to the fair balance which has to be struck between the general interest and the individual interests. And in both contexts, the state, we can trust the state, has a certain margin of appreciation. So I think one of the reasons that religious autonomy is more restricted in Europe than the US is that the restriction requires some degree of faith, partly in legal institutions, but also by the people and within the culture more generally, of the capacity of governments to make complex calls over competing rights. As an outsider, my observation would be that Americans in general are more sceptical about the very notion of government. Not that this particular government is a good government or a bad government, responsible or irresponsible, but they actually have that there's a cultural scepticism about the very idea of government, which plays out and has played out, for example, in this historical debate. In contrast, Americans have a much higher, though declining, I think, degree of faith in organised religions than do Europeans. Now, again, maybe this is partly a matter of historical narrative. While oppressive governments are most certainly part of the history of Europe, the history of democracy in Europe is also about throwing off some oppressive religious practices and religious institutions, about religious groups that actively aided or remained silent or complicit to protect their privileges, their rights and their institutions in the face of dreadfully abusive governments. And of course, more modern stories that resonate in both continents about disenchantment through the handling of things like sexual abuse scandals. From a European perspective, religions have not kept themselves nice. While they need protecting, others may also need protecting from them. Let me then very briefly talk about the second issue, which is the extent to which religious organisations are perceived as just like any other voluntary organisation. A union, a sports club, a political party, a religious group. These are just different ways in which individuals come together to share common goals, institutions which can serve useful purposes but can also sometimes turn against their own membership or those outside. Religious autonomy in its fullest sense is based on the notion there is something separate, distinctive, special, extra about religion that does not exist in these other associations. Otherwise, of course, while governments should generally let groups of citizens come together to pursue their own interests, they also have a right and sometimes an obligation to interfere in the life of such organisations. Now, in the Hosanna Tabor case, of course, it was argued a freedom of association would do the job, it would be sufficient, and the court denied that, and we've heard the quote there in part. But the point was made, the association in question, whether it's a Lutheran church, a labour union or a social club, it should be treated the same way. The court says that result is hard to square with the text of the First Amendment itself, which gives special solicitude to the rights of religious organisations. We cannot accept the remarkable view that religion clauses have nothing to say about a religious organisation's freedom to select its own ministers. Just as a little side note, the Australian Constitution uses almost precisely the same words as the First Amendment, and the text has been interpreted very differently. Again, I don't think the European Court pays such high solicitude to religion as distinctive. A little distinctive, but not as distinctive. So let me just conclude briefly. Participation in formal religious practices and institutions is declining around the Western world, even if the decline is less here than it is in Europe. Members of religious groups are also becoming far more willing to criticise and stand aside from the formal positions of the church themselves. So when the Archbishop gets up and says Catholics believe that, that's almost certainly not true about almost anything in, for example, Catholic doctrine. Many Catholics believe, most Catholics believe, it's the official church teaching that. But there's much more debate inside Europe. Also, inside religions. Also, the percentage of people who describe themselves as religious is declining. The participation in organised religion is declining. Again, a trend far more marked in Europe than here. At the same time, equality has gained ground as an important social norm. Other human rights are increasingly accepted and respected across a swathe of the population, including by religious people. So while courts deal with these issues as purely legal, I think factors such as these certainly do impact on the law, particularly in statute, but I think also in the decision of courts over time. Thank you.
Okay. Thank you, Gerhard.
So thank you very much indeed. I also wish to underline how grateful I am that I can be here at Georgetown University. The last time I was here was 30 years ago, and it's wonderful to be here again. Thank you so much. May I take the liberty, and I ask you, Cole, may I take the liberty to come back first before I make my points on autonomy as understood apparently here, to come back to the first panel, because you raised the question of the circumcision case in Germany, and I wondered to raise my hand to ask a question on that, because I come from Germany, and you were not so fully aware of what the state of this case is in Germany. I take that liberty because I wonder whether we are here not at a point of overlapping fields of individual religious freedom and autonomy questions as understood here. Because we have the family here, parents and children, and that also could be understood. I ask that more than I make that statement. That could be understood also as a religious autonomy case. Just for the facts of the circumcision case in Germany, most of you will have read about it. It was before the decision of this, you would probably say circuit court, a minor criminal court. It was undisputed among most of the lawyers that male circumcision in Germany for religious reason is perfectly allowed and does not constitute any crime. And there is a minority view of some lawyers who were opposing that for some time, and that was taken up by this minor criminal court. It convicted a Muslim medical doctor who, at the request of the parents, had circumcised a 4-year-old boy. With some minor complications. This is why it then came to the court. And the court said this is in a violation of the right of the child to not be bodily injured. And that has to be balanced with the right of the parents to determine the religion of the child. It said that this religious freedom of the parents does not constitute a valid right to overcome the right of the child to not be bodily injured. It nevertheless acquitted the medical doctor because the court said the doctor could not have known beforehand that his activities are illegal. Because it was never said to be illegal before in courts. And so it acquitted it. He did not lodge a complaint to the Constitutional Court, which he could have done if he had had a better counsel, better advocate. It did not go to the Constitutional Court, so it is a final decision. Now, what happened now is that in Germany, in Germany there is no tradition of precedence. No other court is bound by that decision of this minor criminal court. They can decide differently. But the public was now highly alerted, doctors highly insecure, the religious communities of Jews and Muslims highly disturbed. Meanwhile, and pretty immediately, the German government has taken an initiative to present a bill to Parliament indicating that male circumcision for other than medical reasons is allowed under certain conditions of protection of the child in terms of pain and stuff. Very similar to the Swedish law. You might be aware that there has been introduced a Swedish law a couple of years ago, which is pretty much on these lines. The law has not yet been passed. It's not in Parliament yet. It will be in Parliament soon, probably. What puzzles me, that is the state of how it works out right now, the situation. What puzzles me is not so much the reaction of the courts. I mean, there can be a wrong decision of a court. That is something that happens. The court, it is a wrong decision because it did not even mention the right of the child itself to freedom of religion and to be raised in the religion of his tradition. There is a right of the child, not only the right of the parents to religion, the freedom of religion of the child, to be part of his or her tradition. That wasn't even mentioned. It is a wrong decision anyway. But what puzzles so much is that in the German public, this decision was highly welcomed. So in the public debate, highly welcomed decision suddenly. And my question would be, which I would have raised in the other panel, I do it now. The question for me is, how do you deal with intolerance within the society? I mean, it's for a lawyer, it's pretty easy to deal with intolerance by the government. You go to court. But what do you do with intolerance within society? Would be a concrete question, a duty of government to intensify educational aims and to pursue those in public schools in terms of tolerance, taking sides. That would be a question of the role of government in these things. I apologize for taking this up, but I thought it might be a right thing to do because these are the recent developments. Do I have still 2 or 3 minutes? I am somewhat puzzled by the question, what is the difference between the US and Europe? There are so many differences within Europe and probably also within the United States and Canada anyway. And I am highly intrigued by what you say, what the differences are. I thought they were different, but it's really interesting to see a different assessment of how it works out. I see some differences, not so much in substance, but in the degree of how arguments are being valued, how it works out, what weight is given to certain approaches. The approaches are somewhat the same all over the places as I experienced that. I see one difference, which was already mentioned, in the way government is pursued, as positive or negative, basically. I see also a somewhat narrower approach, what taxpayers' money does in these questions. In the US, as I experience it, the argument that when government money, taxpayers' money, public money is involved, then the groups have to comply with some general anti-discrimination or this or non-that field. So they have to be all alike. At least in Germany, and now I can only really speak about Germany. In Germany, the approach is different. I think really markedly different. The difference is when the public money is there to support the identity and the differences of groups, to have their plurality underlined, to have their plurality supported and endorsed. So the money goes into the differences and not into the making everything equal. So it is an approach to endorse plurality by public money rather than to suppress plurality by public money. So that seems for me to be a difference. We can discuss certain points that have been brought up in perhaps later. I will not mention them now. I would make two final points, perhaps. One, to the cases you already mentioned, Carolyn, in the European Court of Human Rights, and there seems to me to be a tendency which represents a tendency overall of Europe. And that is a slow, a tacit increase of public government involvement into the balancing processes. So what weight should be given to certain approaches and different ideas and different rights? And that has been taken over gradually by state courts. That is a tendency I see. It's not very far gone yet, but it is this tendency. So that is one of the developments. The other developments, I would mention one, and I apologize coming back to Germany again. We have recent cases pending in the question of whether there is a right to strike within religious premises, whether religious personnel, whether trade unions can strike within hospitals run by churches, religious communities. In Germany, that was accepted until very recently, that there is no right to strike, and the argument of the churches was accepted that these institutions provide, the employees and the employers provide together a community service, and they call themselves a service community under Jesus Christ, which cannot be disrupted by antagonisms like strikes and lockouts. So the employer could not lock out people, because then the employer, the church employer, would disrupt the service, the community service, and the service community under God. That is now being highly disputed, and the trade unions have filed cases before courts, and there is a court case pending before the federal the Supreme Labor Court. And whatever the Labour Court says about the right to strike, it will go to the Constitutional Court, and then we'll have a Constitutional Court decision. Whichever side wins, the loser will go to the Constitutional Court. So that is one very concrete point of whether there is an autonomy of religious institutions towards the general way of forming labor relations. They have their own labor relations inside. So I'll stop with this, and thank you very much.
Well, thank you very much. Let me just pick up on that last note for those of you who are not aware. The European Court of Human Rights has just agreed to hear in a Grand Chamber case from Romania involving unionization within the Orthodox Church. And this is very interesting because it includes a union of both clergy and non-clergy, so it raises a lot of these kind of issues. But let me open things first now to the panel to let them respond a little bit to each other, and then we'll open things to the floor.
Sure, thanks, Cole. If I may, this question of individual rights versus institutional rights is an interesting question. Let me try to I'll read you a quote from the Hosanna-Tabor decision that is very interesting on this point. And it is again from the concurrence by Justice Alito and Justice Kagan. So they say, by way of introduction, throughout our nation's history, religious bodies have been the preeminent example of private associations that have acted as critical buffers between the individual and the power of the state. And they go on to say, it is easy to forget that the autonomy of religious groups both here and in the United States and abroad has often served as a shield against oppressive civil laws. And they don't say this, but it would be difficult not to think of the role of religious churches and other religious groups in our own civil rights movement in the United States in the 60s. So what I draw from this is that perhaps, certainly on this view, there isn't a sharp dichotomy between individual and institutional rights. Instead, the two may well, and have often in the history of this country in particular, reinforced each other. And the other idea is that we have here a notion of a more robust notion of civil society that recognizes the autonomy of groups, which are, after all, voluntary associations. No one has to belong to a church. No one has to work for a religious organization. They're voluntary organizations. We've never had a sort of throne and altar arrangement in the United States. We've never had that. And so there's no question of compulsion. They're voluntary associations, and they serve, on this view, a function in society of ensuring and sort of amplifying individual rights. And so on that theory, a constitutional protection for religious autonomy is a good thing for both. I would also add, and this is something that my Australian colleague pointed out about the American Constitution, which is that the Bill of Rights protects not only individuals, but also groups, organizations, even corporations, against government power. And so the idea that we need to construe the Bill of Rights or the Establishment Clause or the Free Exercise Clause in order to cut back on institutional rights is sort of a notion that runs counter to the sort of structural theory of the Bill of Rights in the Constitution itself.
That gives you a good opening.
So if you think of two trends in American religion, right, that religion is growing more and more individual with a lot of emphasis on individual spirituality. And then, of course, the second great trend is the growing presence of the non-religious in the population. The largest group is the nuns, right? Not the good nuns, the NUNS, who educated so many of us, but the nuns, those of no faith. And so I think if you look at those trends together, that they need to make us first suspicious of religious institutions, but also suspicious of the idea that religion deserves special treatment under the Constitution, right? And I think that's the problem that exists now and into the future, right? If you say, well, right, if you look at religious freedom and then put it up against equal protection and due process and the growing number of people who are individual in their faith or have no faith at all, then to repeatedly to say that you need to have special exemptions for religion or special rules for religion becomes more and more problematic. Now, as to associations and voluntary associations, that's why I think in the long term, what we have to do is develop one principle of freedom of association that governs all groups. Now, when the Solicitor General made that point before the Supreme Court, both Justice Kagan and Justice Scalia almost jumped off the bench, right? You can physically see them both saying, no, the fact that we have religion clauses means religion deserves special treatment. But see, I don't see how that idea can hold against the developing diversity and pluralism and non-religiousness of the population. I think that the more that you have special rules for religion or a special sense that religion does something special, adds something extra, is really good in a way that secular institutions aren't, then you're always going to be undermining liberty and equality. And so the court for now is not ready to go to the freedom of association route, but I see that as the best way for all of us to work out how can we have voluntary associations that can stand up to the government, but that also are equal in the rules that they have to follow.
Let me pick up on 2 points that particularly were made first. One is about voluntarism in religions and the notion of religions as voluntary organisations. I think that needs to be problematised a little bit. At a certain level, it's true. It's one of the important parts of liberal democracy is the notion that people are not necessarily compelled to remain in religion. I think we have to acknowledge that at least for some religious groups and for some people within those religious groups, there's at least a very high cost that needs to be paid for dissociating from the groups. The term voluntary needs to be taken, I think, with a grain of salt and grain of scepticism. A lot of women in particular don't feel that they have that same degree of voluntarism. And there are people who exist within those associations, particularly children, for whom the term is problematic. And I think it becomes even more problematic when we talk about the employer-employee relationship. I mean, it's a very easy thing to say you don't have to be employed by a religious organisation. But in times such as these, in particular, many people desperate for employment, and sometimes and in some places the only employers on offer in the area in which they are skilled or specialists are religious organisations, then to simply say, it's all right, you don't have to eat, you don't have to pay off the mortgage, can effectively mean what we mean by voluntarism. It's a fairly high price you ask people to pay. And the employer-employer relationship, seen as a voluntary one, I think is not always the most useful lens. The second issue is the rather benevolent view of religion in protecting individual and civil rights, and the civil rights movement was given as an example. There's a state with oppressive laws, there's the poor individual being harmed by those laws, and religion can, and one must say, has not uncommonly played an important role in protection. But the reverse is also true. Religious justifications, religious institutions have been a strong part of perpetuating laws that have been terribly oppressive and in opposition to civil liberties, have been actively involved in the oppression of civil liberties themselves, and have opposed movements. The people on the other side of the civil rights movement weren't sort of godless atheists. They were, on the whole, people with their Bibles, saying that segregation was required by Christianity. The people on the other side of the slavery debate were not radical secularists. They were people holding their Bibles saying that slavery was mandated by the Bible. And one of the things that I think religious organisations need to understand when they face scepticism about, for example, their opposition to equality for same-sex couples or some aspects of women's rights, is at least for some people outside religion, the temptation is to say, here they go again. Not, this is wonderful, religions protecting individual liberties, but here religions go again, saying people are unequal, the Jews are Christ killers, people from Africa are inherently less equal than white people, that segregation and interracial marriage is clearly prohibited. This is just the next manifestation. And in 20, 50 years' time, the vast majority of religious groups will look back on it with the same embarrassment that they now look back on or try and pretend away their involvement in these other oppressive movements. So I think today, I found the first panel, this is partly a response to the first panel as well, I think we do have to face fairly squarely that religion is not simply a voluntary benevolent force protecting the individual from an oppressive state. It often sides with the oppressive state against the individual historically.
Yeah, I would agree on that, but that is life as it is. In all institutions, the states are not kind, trade unions are not always, political parties are not always nice people, and in churches there are also people who are not so nice, and institutions can fail. I completely agree with that, but it is nothing specifically religious. I wonder a little about the term, the power of institutions. I mean, if you say the power of institution and say this is versus the individual, the right of the individual, I think one tends to forget that institutions are made of people. There are individuals who belong to churches and religious communities who want to belong to this religious community and want to have it as it is. And they cannot exercise their freedom of religion when this institution does not exist. And it would be different. So the people behind the institutions have to be taken into account also. Institutions are not just one cold stone sitting there. And then perhaps also a question, the answer of how institutions fail. Yes, but let me give examples, I apologize again, from Germany. The Roman Catholic Church and a very tiny part of the Protestant Church were the only ones who were institutionally against the National Socialists. So the opposition against the Nazis was within these institutions, not the institutions as such, but within the institutions, and without these institutions, it would not have been. The Protestant Church was the main factor in overcoming the, I say, somewhat repressive regime of the Eastern German Democratic Republic, as it was called. Without the Protestant Church, communism would have not, and without the Catholic Church, communism would have not been overcome in our days. One may regret that, but this is something I think one would also have to see. And same-sex marriage, I don't know enough about the United States and how it really works out. In Germany, same-sex marriage, I call it same-sex marriage, it's a little bit different in Germany, same-sex couples, was a movement from within the Protestant Church. That was a church thing. And it was the Protestant Church who first, how do you say, benedicted couples who came to the altar and said, we want to be together and take responsibility for each other. It was a church movement. So I mean, I see that it is very often very false, but it also very often very right. So I don't see this point with institutions or not institutions. Sorry.
Okay. Let me exercise my prerogative as a chair, and then we'll open things to the floor. I think one of the things that is striking as one listens to contrasts between the U.S. And Europe, recognizing, as has been pointed out, that Europe is not one thing; it's very, very diverse. But I think a number of the panelists have picked up on the notion that there is a kind of American sense that liberty is a zero-sum game you play with the state, and if the state wins, you lose. Whereas there is a much deeper sense that, sort of on the continent, that the state is a vehicle of liberty, and it helps to actualize it. There's a wonderful book on the German idea of freedom several years ago that makes this kind of contrast, and it would apply across quite diverse systems, and it is a greater expectation of the state as sort of a bearer of responsibility, an actualizer of freedom, as opposed to a key threat to freedom. And it seems to me that one of the ways this is playing out in the cases is that you see the state or the court saying, yes, there is autonomy, but we retain jurisdiction to check the borderline questions. Little ambiguous, actually, in the United States, because there's a footnote in Hosanna Tabor saying that it's not a jurisdictional issue. It's but it does seem to me that question of the extent to which the state retains jurisdiction to check the bad cases is an interesting question. I mean, in a sense, several of the speakers have talked about how the church can become a problem. It can become too strong institutionally. But then you have to ask, so why is it we assume that the state would be the solution? In freedom of speech, we talk about more speech being the solution rather than government regulation. Here you sense my American instincts coming out, of course. But I think one of the hard questions is how much jurisdiction should courts and state exercise in these areas, and how much do we leave to rights of exit so that if there are institutions that are problematic, people can go elsewhere? How does one deal with those questions? So. I don't know if you...
Those are some large questions,
yes.
Cole.
2 minutes.
2 minutes. So one very basic idea that you see in our Constitution, as it well explained in the Federalist Papers, is that we in the United States scheme of things, we approach these questions by dividing up power and by making sure that no one locus of power predominates over others, that you give power to the federal government, you give power to the states, you give power to localities, you divide them up both horizontally and vertically, and this is a sort of functional arrangement that makes sure that nobody can get the upper hand over anybody else, and we have this sort of equilibrium. Now, this equilibrium has changed radically over time, particularly with the Civil War amendments, but you've got this sort of view of how to protect people, and it's a very realistic view. Well, I'll just say this, that the framers had a particular view about human nature, and that it was not perfect, that it needed to be checked, it needed to be balanced, and that the idea of locating a large amount of power and meaning in one institution is a really problematic thing. And so we see that in our concepts of federalism and separation of powers. But I go back to the sort of critical buffers quote from Hosanna Tabor. The reason I think that a religious organization needs greater autonomy, frankly, than a secular organization is because historically in our country, and throughout the world, of course, but historically in our country and still today, religious organizations provide a locus of meaning for people that is quite different from secular organizations, and so we want that. We want areas of meaning and purpose for people in our society to depend not merely on the government. That we want competing, we want competition, we want more religion and more meaning and more plurality to flourish, and that this is a form of protecting liberty. As a concrete example, as far as government expanding at the expense of religion, Professor Griffin brought up the HHS mandate, which we at the Becket Fund are somewhat familiar with. So you see this large movement towards a federal, presence in the healthcare industry and in the insurance industry. And you see as one of the first things that comes out of it this mandate that requires all employer health insurance to cover FDA-approved contraceptives. And there's an exception for religious employers, many of you may be aware of this, some of you may not, that is so narrow that it excludes all manner of religious institutions, such as Georgetown, Notre Dame, some of our clients who we represent in this, the largest Catholic broadcasting network in the world. These are not religious anymore because the government has defined them out of the sphere of religious organizations who have any conscience rights. And so there you see a very dramatic example of government expanding at the expense of the institutional integrity and autonomy of religious organizations.
I think many women have needed the government to protect our equality and our civil rights, and women aren't alone in that. And if you say, as Kyle just said, right, religion adds something special or extra, meaning that other groups don't have, I don't think secular groups or good secularists or philosophers would concede that point, right, to say, oh, religion adds something special or better, right? I think in terms of our comprehensive doctrines or worldviews, we expect equality, and we hope that our laws will protect us against inequality. And that's what's at stake in these discussions, right, is that the government, as bad as some people might think it could be, right, if you look at who's going to protect women's rights against, or gay rights, or African American rights against religious majorities that might want to limit those rights, then I'd say don't forget that the government is there to protect us. And of course, the government is subject to us if we get out and vote. And so, right, which isn't happening in the religious organizations. And so you say, right, government might do bad things, but it also can be a force for good. And I think in the anti-discrimination area, it's a tradition that we have some reason to be proud of, right? That we have laws that protect people against discrimination. And that those, as Carolyn said, right, that it's a mistake to think that it's religious insight alone that has somehow promoted equality, right? That religious groups have been right and wrong about women's equality. And so we look to the Constitution with its Equal Protection Clause, and we look to the government to protect rights that everybody has to share, right? That they're constitutional and legal arguments, right? They're not religious arguments. That's why in the first session, right, I think our starting point when we figure out what the laws should be has to be our basic constitutional principles, that we all are entitled to equal protection and due process, and that's the starting point. And always deferring to religious organizations won't protect those values.
I think the question of how much faith we put in government is actually an extraordinarily difficult and complicated one, because you do want a set of robust civil society institutions. And there are good reasons, even for non-religious people, to want to see the liberties that allow religious groups to flourish, at least if those liberties are also extended to non-religious groups. And it is foolish to put too much faith in a government, even if governments can at least be voted out, which again is often not the case with religious institutions or power structures. But those institutions and power structures can be undermined if sufficient numbers of people say, actually, we don't buy this. The decline of the power of the Catholic Church in Australia, for example, which is still probably the single most influential religious body, is in part tracked in terms of its membership and the extent to which the membership buys into what the religious leadership says. So in a democracy, if people are moving away from religious institutions, those religious institutions will have less power. That's been perhaps suggested it's inherently problematic. I think that's a result of freedom and democracy. So I do struggle with to what extent you want to give the government a free hand with degrees of control over religious organisations. All of my instincts, in fact, are towards something like a ministerial exception, except when I see how it's been applied in this country. And when I see that and the extraordinary scope that has been given and the extraordinary deference to what to me looks like bootstrapping by religious organisations, then it starts to worry me. So I think we need to recognise that governments can be forces for good and ill, but what the Tudors would have called overmighty subjects can also be so. And I know describing religious groups to some people in that as subjects will probably be somewhat controversial. So I'll quickly move on to Professor Roberts.
Thank you. Difficult question you raise. And I see I hear two questions. One is the one which is the special thing about religion, and the other one is what about government? The first question I would answer very hesitatingly to make general statements, but I see in religion a difference to other institutions, to other perceptions of life, that religion pervades all aspects of life and is not just one interest among others. It goes through all layers and all aspects of life. That is one difference to societal groups and special interests. And another difference is that religion sees to the beyond. And I don't see anyone else, any other approach that has this mind for that there is something different, something really deeply different, the other, not us, not what we see. And that to me is also something which makes it very, well, puts things into its place and makes things here relative. And I see religion the only one. You can point at others, and I'll be happy to see others doing that, but I only see religions doing that. For me, this is also a very deep sense of separation of powers in this. And I would think that one would have to support this separation of power and not leaving it to just one field of life. The other question of government, my hunch is that we are here now comparing the US with Northern Europe. And there also is a Southern Europe. And that makes general statements, again, somewhat ambivalent. calling it Northern Europe, yes, I completely agree. There is a difference in respect and difference of approach to the role of government. Government is something, in substance, good. In Northern Europe, certainly in Germany, in France, for different reasons somewhat. In Germany because of the 30 Years' War, where the religion destroyed everything, and then the state came in and repaired everything. That is one. In France, the overpowerful Roman Catholic Church being fought by La République being a religion itself in a way. Positive. On the other hand, if you have Southern Europe, go to Greece or go to Italy. Silvio, hope I don't say it too silly. Good. So you will set it into the right tone. But I see in Italy a much stronger focus on family than to state. And friends somewhat. And in Greece, the state, that was Turkey. And that was different. And if you turn to the government, you turned to the foreign power for centuries. It makes a difference in approach, and I would think one should see that.
Well, let's open the floor. Let's see. I've seen a lot of instant hands. Let's see. Let's see. Lauren Homer, and then Tura, and then Sophie and Rick. Yeah. Why don't we collect 2 or 3 questions this way? Those 4, and then we'll take another round.
Please identify.
Yeah.
My name is Lauren Homer. I'm a lawyer who works on international religious freedom through an organization called Law and Liberty Trust. But I wanted to address this kind of incendiary bomb that was thrown in, analytically equating slavery and segregation with same-sex marriage and reproductive rights. Slavery and segregation were state actions. There were state laws that were oppressing certain groups of people, and both of them were repealed with constitutional amendments, among other things, including the Civil War. But same-sex marriage and reproductive rights are not being imposed by the state, but individuals are saying that religious groups have to change their doctrines, which they've held for thousands of years. And I think that's a real distinction that you've failed to make. There are many religious groups. There are some religious groups that agree with those positions. There are some that don't. But for government to force them to change their doctrines, I think is a very fundamental distinction. And I'd like to hear your comments.
See, so Professor Lindholm, then.
Okay, I am Tore Lindholm from Norway. I'm a member of the Oslo Coalition for Freedom of Religious Belief, with Lena sitting here. And I'm an emeritus professor at the Norwegian Center for Human Rights, University of Oslo. And by the way, I should say I am a member of the Church of Norway, which is a Lutheran state church, Commission on Human Rights. I have one question. I should raise it to the person whose name I never discovered, but I shall in due time, from the Becket Fund, okay? Because you're sort of now the defender of the decision in this case involving a Lutheran sister church, Hosanna Tabor case.
Sure.
I think it was perhaps wrongly decided, so I will sympathize with your decision. And here's my question to you. I think that with Carolyn, I share this inclination. Yes, the ministerial exemption regulations should stand, except how it is often understood and practiced in this country, the United States. And here's my reason. There are some cases where obviously it would be the right to give the decision, just to give the church or the mosque or the synagogue to support them against a certain employee for certain reasons. But in other cases, it should go the other way. And I feel you guys here in the US are, who have this view, making religious autonomy sort of a sacrosanct thing. But sometimes it can be very unjust. I think the main consideration has to be not whether you should have absolute freedom of protection against what the church or a church, for instance, might decide on your job, or always side with the church or similarly. No, it has to be a question of basic fairness. In a case where and maybe that could be the organist case in Europe, where there are no other jobs available to you. You have produced a child outside wedlock. I think the European Court, if I got that correctly, decided in a just way, because it was such hardship for that person to have to leave his job. There is no other. There are very few organist jobs around. That is his profession and his life story. I don't know the case here. Cole and I, we have always been quarreling when we have time for that about the Amos case.
We can continue that later.
Yeah,
so.
that later. But so I would like to say, is it always, as a matter of U.S. principle in the constitutional system, that there should always be the decision should always be in the favor of the religious body, provided the person who is fired, for instance, hasn't committed a crime? That's my question.
Okay, so next to Professor van Bijsterveld.
Thank you very much. Sophie van Bijsterveld, Tilburg University in the Netherlands. I have a question to Professor Evans and to Professor Griffin. And I would like to pick up on the theme of the first panel. We were talking about the religious argument, but in fact there are always many different religious arguments, and leading to many different religious points of view by various churches. And the same is the case, I think, with the way autonomy is actually used in practice. It's also not one monolithic block where all the different religious groups and churches use autonomy in the same way, but there's also a kaleidoscope of ways in which this autonomy is played out in practice. And my question is, isn't that just a matter of really democracy at work? And shouldn't you just let this societal democratic process take the lead? And I heard you also talk about the role of the law. And indeed, I agree, franchise for women and a lot of good things that have happened have been produced by the law. But the law wouldn't have been produced if there wasn't support for that in the broader society, and if these things weren't debated within the society from different points of view. And therefore, you need this autonomy to actually be able to discuss this. That's my first question. My second question is to Professor Duncan. I am myself very much in favor for religious autonomy for all the different reasons also you mentioned. My question is about the situation in the United States. Do you think there are also limits on religious autonomy, not so much in the substantive sphere, but in the procedural sphere, like requirements for procedural fair play for making certain decisions with the church, within a church and religious group, such as, for instance, audi et alteram partem, here also the other side before you make a decision.
So let's see, Professor Torfs, did you want to also? Yeah.
Very quickly, and it joins maybe some other comments. I'm Rick Torfs from Louvain University. First element, we are always talking about concepts in my eyes. So we have a very conceptual approach on things. And what strikes me is that normally an Anglo-Saxon system very often starts from a more inductive method, and we see here the opposite. We start from large principles, which then are implemented on concrete cases. A continental European system is more often the opposite, starting from deductive notions, and then we deduce. We see here the opposite, a balancing of, let's say, various interests. So what's going on? Are we losing our identity? That would be dramatic. So that's my first element. My second element, what is the elasticity, in fact, of a system? How far can one go in human rights? That joins a little bit what Tore said. Imagine for a moment that the Hosanna Tabor case would have been a very unsympathetic case, with the church being rude, discretionary, etc. Would then indeed also the same solution be chosen? So I remember the Smith case, that was peyote smoking, not very sexy, and that led to, let's say, negative decision for the defenders of religious freedom. And it was a problem for a long time. Then we came to the Hosanna Hosanna-Tabor case, that's, I think, here you can say, okay, here we are really dealing with ministers. So then I wonder, what is the influence of facts? Aren't we too easily playing with concepts and neglecting facts from time to time?
Okay, well, let's take that. That's a very rich set of questions, and I'll try to look this way. But if we could give everyone a chance to do those, and then we'll, depending on the time, we'll take some more.
So there's a cluster of questions about the Hosanna-Tabor. I think they all, so let me take the balancing and the fairness issue. So, and I'll connect it up with the professor's question about facts. The facts of Hosanna-Tabor aren't particularly good for the church, just reading the decision. I mean, here you have a woman who's been diagnosed with narcolepsy, who's undergoing some sort of disability. And so she says, I've been fired for that reason. And the church says, well, no, you haven't been fired for that reason. You've been fired because you went around the normal internal dispute resolution process, which we have a theological rationale for, and you've created all this disruption. And so, we're going to fire you for that. So that doesn't strike me as a particularly good set of facts for the church. So what about the fairness? Why didn't the court say, look, let's try to figure out how to fairly do this. Let's look at her opportunities to get a job elsewhere. Let's look at the impact on her life. That all sounds great. However, what I hear, and I think what a lot of American lawyers who might support the decision, and maybe the 9 Supreme Court justices who also, agreed, when they hear balancing and fairness, they hear aggrandizing the power of a federal judge to enter into a realm of decision-making where we will quickly get into theological disputes. It would be very easy if we got into fairness to say, well, how important is the Lutheran internal decision-making process, which is based on the New Testament, how important is that to the church, to the way the church functions, versus the impact on this woman's life of not being able to come back and teach at this church? If that's the fairness decision, that to an American concerned with a genuine separation of church and state, I am concerned about a federal judge having the power to weigh those two things together, right? I think that's what explains the court's focus on the Establishment Clause in saying there is a sphere of decision-making that we don't want courts to get into. And I think that's what explains that part of the decision. I can tell from your face that that's not going to satisfy you, but I think that's what's going on.
Okay, well, I'm glad I got one vote in Norway, although I can't get a vote in the United States. So I think the most troubling thing about the Hosanna-Tabor decision was the statement that the firing didn't have to be for religious reasons, because I think this picks up some of our concerns about the role of religion. And so it's not as if a church came into court and said, we believe in discriminating against the disabled, and therefore we need the freedom to discriminate here, right? What the court said was, or we believe in sexual rights. There are a lot of sexual harassment cases, right? And so you say, well, there's not a church I know of that's going to say, well, we practice sexual harassment, we believe in it. But if you have the kind of strong ministerial exception that the courts have recognized, what happens? You don't even get into why the person was fired, right? You don't get to investigate the facts. You don't. Under the ministerial exception, the only fact that matters is what label you put on the employee, right? Once the person is a minister, you're out of court, right? So the factual record isn't developed. We don't have, and I think in most of these cases, a jury could go in and think, do we really believe that that person was fired because she was disabled, right? She went on leave, she tried to come back. People in the parish were saying these things about whether she was ready or not, right? A lawsuit lets the facts be developed, and then plaintiffs can win or lose. They frequently lose. But the problem with the ministerial exception is it says all we have to do is label someone a minister, and that's what we're seeing now in the lower courts. Will the courts be really deferential, right? If a church says that person, right, that Jewish studies professor is a minister, the case ends. And so you don't even get to fundamental religious belief, right? The power to discriminate is protected because in these lawsuits, you don't have churches saying you've got to protect our religious belief in disabilities discrimination, or you've got to protect our religious belief in racial discrimination, right? You've got courts saying, oh, that person's a minister, the inquiry ends. And so I think that strikes the balance in completely a wrong way, because my underlying principle is that religions don't get a special pass on the law, right? If we had a church of slavery, we wouldn't say that was acceptable, right? We would say, no, the laws have to be followed. And that's the tension now, I think, in your theory of religious autonomy or the individual, whichever side you pick, right? How will you balance the anti-discrimination laws against claims for religion? And I'm thinking that I probably sounded like I was a super believer in the states or the governments, which I'm not really. But back to the topic of the first panel, I don't think we can find agreement on religious grounds, right? And so if all we keep doing is going into our democratic voting places saying, listen to my religion, follow my religious belief, impose my religious beliefs, I don't think we'll find common ground. And so I think we need a better base for finding common ground than thinking that all we can keep doing is arguing our religious views. I don't see the way that we can develop laws that govern everyone if we think they should be based on religion.
I'm not surprised that I got asked the question from Lauren that I did. Let me say I wasn't saying they were precise equivalents, but I will come back to the way in which that this is slavery and segregation, perhaps to say, compared to same-sex rights or marriage. It was partly in response to perhaps a rose-coloured view of the role of religion in history. It's very easy for us to look back and, whichever side of the debate we happen to fall on, portray, for example, religions as just wholly genocidal, bloodthirsty, torturing institutions because they had been all of those things. Or to see religions as civil rights protecting, anti-slavery, crusaders for the rights of women, because they've been those things too. But sooner or later in those civil disputes, the state, through laws, through constitutional change, whatever it might be, and depending on the system of government to some degree through the people, has made a decision about which of those. You can't just say, well, you might think slavery is theologically mandated and I might think slavery isn't, so let's just all go our own ways. You can own slaves and that's fine, we respect that. I'm not going to own slaves, that's fine. You need to respect my right not to do that, and that's all morally fine. Sooner or later, the state, in fact, backs one moral position or another. And in all of the cases that I gave, these were deeply held theological views. Right? The southern slave owner who was dispossessed considered him or herself, himself, to have had both his property rights intruded on, but also to have been told, you have to change your theology. Your theology is wrong. A theology that promotes slavery is wrong. The anti-Semitism that underlined all sorts of laws against Jews in Europe, based on the idea, the theological commitment that Jews were Christ killers. And sooner or later, I think most of us would say that the states of Europe, having seen the way that this came to a terrible, terrible conclusion, but that was only part of hundreds of years of historical persecution of the Jews across Europe, would say, look, you can believe these things in your own churches, and I certainly wouldn't be wanting to force any church to perform a same-sex marriage who wasn't the same, but we're going to have to come down on a side civilly that says, yeah, we think your theology is wrong. Now, we're not necessarily going to force you to participate directly in any way, but we're going to say your theology is wrong insofar as it undermines the equality of citizens, and we're going to protect that equality. And to that extent, I think there is an equivalence between slavery, segregation, anti-Semitism, and things like same-sex marriage today. Oh, and largely I agree with what you say. I'm not arguing against autonomy of religions to large extent. The question is about boundaries. Can one have a healthy social debate and lots of differences and points of view? Is it absolutely necessary for that to exist, that religions have an unfettered right, for example, to sack anyone who works for them for any reason and with no procedural fairness? I would argue it isn't.
Can I just add that that's not what the ministerial exception is, and that's not what the Supreme Court recognized. It's a robust principle, but it applies in the Hosanna-Tabor case. It's not the right to sack or fire anyone for any reason. It's the right to make decisions about the firing or hiring of ministers. And yes, there's a question of how broadly that needs to be defined, but we're talking about the hiring, firing of, let's just say, substantial people in the organization that have something to do with the mission and the message of the organization, right? And it's whether we can have an employment discrimination suit about it. So it doesn't apply to non-ministers, and it also doesn't apply to a whole range of lawsuits, be they private or governmental, that could affect the church. So what we have, I think, is a robust principle, but the applicability, the breadth of applicability of the principle is still very much up in the air. So I don't think it's right to say that it's a right just to fire anybody you want for any theological reason that pops into your head.
But I entirely agree that that's an accurate description of the Hosanna Tabor case, but it is also accurate to say that there are many religious groups who are arguing for that much more expansive understanding.
And pre-Hosanna Tabor, I mean, starting in
1975,
the lower courts had all developed a ministerial exception, which tossed out tons of cases, right? Equal pay cases, family leave cases, age discrimination cases, disabilities, and so forth. And there's no good reason to think that those precedents will be cut back now that the court has recognized a ministerial exception, right? In fact, they confirmed the existence of a ministerial exception case, and so I think there is reason to be concerned, right, that minister is already being defined broadly, and the scope of the anti-discrimination laws to which it applies is already very broad.
Thank you very much. I like very much the question about facts and doctrines, and so perhaps two remarks on that. One to the shoot case, which has played a role here, just to remind us that, at least I read the case in this direction, the Human Rights Court in Strasbourg did not say that the interests of shoot overruled the interests of the church and right against the right. They just said that the German courts had not applied a proper balancing technique. What would have been the outcome is an open question. And it could well be that if the German courts, in the view of the Human Rights Court, would have applied a proper balancing, that then would have been sacked anyway, for good reasons. But the courts in Germany, as the Strasbourg court said, just did not apply this test appropriately. That was the shoot case. So one cannot say that the chances of him to get another job are so important that they overrule the interests of the church. The other question is, and I think we are coming to something where we, from my point of view, are on the same lines. And that is a question of the factual assessment of what is in fact important and what is not important. The examples you gave, I mean, are to me completely convincing. The church is against slavery, is in pro-slavery. Sorry, is pro-slavery, or is fighting for racial discrimination, things like that. That is not acceptable. There are limitations to church autonomy, religious autonomy. The question is, why is that not acceptable? Why is that not acceptable? You have mentioned extreme cases, which most of us, all of us, probably would say, okay, we could not accept that. We have not yet, from my instinct, we have not yet an explicit explanation for when the borderline is reached. Where is the borderline? Now, when you say same-sex marriage is as important as don't discriminate against colored people, then you would probably say, well, yes, then we overcome religious perspectives. I wonder whether you can do that, whether these are really these extreme cases. And I have no answer to that. But I agree, when there are extreme cases, yes, then one would have limitations to autonomy, as for any freedom.
I just have to point out that the extreme cases that you mentioned, so slavery, racial segregation, governments backed those, yeah. Right? So the government, and by the way, the Supreme Court that gave us in any decision, pick any decision that you like, that same Supreme Court gave us Dred Scott versus Sanford and Plessy versus Ferguson. Yep. So forgive me if I don't put I don't put all of my trust in religion either. But forgive me if I don't put all of my trust in secular government either. No. I mean, and for every example of a religious government that oppressed people, well, how about atheist communism? How many people did it kill? So it seems to me that, and someone pointed out that human beings are the common factor in all these organizations, right? And so maybe the problem lies there.
So let me look. I've been told we can take a little more time, so let me take some questions from this side. So from you first, then from you. Yeah. Michael, get there fast. Okay.
Yeah, my name is Anna. I'm from the Church of Scientology here in Washington, D.C. And I do have a question probably to everybody, but first of all to the panel on Germany, because it was very interesting. And my question here is, like, when you have a religious group that promotes slavery as opposed to be against slavery or something, there should be, like, I think, some more basic laws protecting that, like protecting individuals from that. And how can we think of, like, guaranteeing the human rights actually in Germany particularly, as opposed to restricting the autonomy of religions and giving them extra rules, extra regulations, cutting out their doctrines that they had for 1,000 years? Like, how can we guarantee that everybody follows the human rights, the Universal Declaration on Human Rights, as opposed to cutting the rights of somebody to also have a religion? If my question is unclear, I can clarify a little bit. Like, I'm just thinking that, you know, you can have a little group which is maybe like promoting slavery, and there should be some basic law to protect people from such a group. But then versus like giving extra regulations against someone's doctrines that have existed for a long time and they don't promote slavery. But then when you restrict, when you give government more power to interfere into this area, it seems like religion, the right to religion, gets cut too. Like,
do you refer to a specific case?
No, in overall, like, just what can be done so that the Universal Declaration of Human Rights gets more obeyed to, like, followed.
Okay.
Hi, Mark Rienzi from Catholic University of America. Two questions, one about individual rights and one about whether religion should get special treatment. It seems to me that the presentation of this as a conflict, as a zero-sum game, a conflict between religious organizations and individual liberty, is in part driven by a really broad description of individual liberty that isn't quite consistent with the way we normally think of, say, constitutional rights. So, for example, Roe v. Wade says there's a constitutional right to abortion, and Casey says that. Fine. That's a right that says the government can't stop you from getting an abortion. It's not usually thought of as a right to force other unwilling private people who don't want to give it to you. Lawrence v. Texas establishes a constitutional right to gay sex. Fine, it doesn't establish a right to make unwilling private people participate or somehow be involved in it. It seems to me the view of this as a zero-sum game in some ways stems from the idea that we're saying the right to have contraceptives, to take the HHS mandate as an example, includes not just the right to have them without the government stopping you, but the right to go force some unwilling private person or institution to give them to you and to deny them their ability to say, well, I have a different view as to that, and my view is that's not something I want to be involved in. And while some religious liberty cases may really be zero-sum games, it seems to me many of them are not. The HHS mandate is a great situation. If we really do believe as a society that there ought to be a right for everybody to have these drugs all the time, the really easy answer is that the government can give them out, or willing people or willing parties can give them out, and we don't have to drag unwilling people into the process if they don't want to be there. Secondly, as to whether religion gets special treatment, I guess this is mostly a question for Professor Griffin. I understood you to be saying you don't think it makes sense to treat religion as special, and I'm just curious what that means for you, your view of the Establishment Clause. Do you also view religion as not special there, or do you think at that point religion becomes special and we need to give it different treatment than we would give, say, environmentalism or any other secular philosophy? Thank you.
All right. We're drawing to the end of the time, so we'll have to give even less than 2 minutes, but if we could, people would like to respond. You'll pass?
I'll
okay,
pass,
that's very
since
short.
I talk so much.
You want?
I think the mandate is a question that the government passes laws that, as with the ministerial exception, right? The government passes laws that regulate employers and that we want the government to have some regulations, and so my position on the mandate isn't based on a view of individual entitlement to contraceptives. It's based on a principle of religious organizations complying with the laws as other groups do. And I'm willing to extend the Establishment Clause to, as the court has in religion right, to anything that's equivalent to religion. So a secular group, an environmental group, I don't mind applying the principle broadly across what seems to be non-traditionally religious.
Be interesting to think about how that would work in practice. You may be a little surprised that I think I actually agree, at least to some extent, where law can, it should try to be imaginative about not creating a conflict with people's most fundamental rights. If there are other ways of serving the rights of, if there are two rights that are potentially in conflict, and there is a way to resolve them that allows both rights full play, it is better to take that path than to take a path which gives one right full play and restricts the other when there is an alternative. There's always a question as to when there is a realistic alternative, but in the United Kingdom, certainly the government is in, it certainly used to be, in the business of giving out free contraception as a public good. And so, now, I'm not sure whether that would go down well with the American public either, I have to say, but there you go. I do think part of the zero-sum game is an expansive notion of individual liberty, but I also think it's an expansive notion of what religious liberty requires. And once you get to the point where religious liberty requires that people be free from law to the extent that their conscience requires, in a pluralistic democracy, I think that is an overexpansion of a traditional understanding of religious freedom, and I think simply an unsustainable one. So if there's a conflict, I think it's also partly because of a fairly expansive view that's being taken of religious liberty.
Anna, you have asked a rather general question on how best to implement the human rights, I take it, as expressed in the Human Rights Declaration of the UN. I would make 4 points very briefly. One is that you need a legal order that is in line with those commitments. And secondly, you need an education for the people to follow these values that are inclined in the human rights. It's a value-based thing. You need independent courts that apply this legal order, and you need a general culture of tolerance. So all these legal ideas and legal ways of doing things will not succeed if this is not based in a general culture. You have that was said in the first panel also. It will not succeed if there is no culture backing that.
Well, I think we've had a very interesting discussion. I think we all, probably many of us are here because we know how crucial these issues are, and they will continue. And part of what's needed is finding ways that really will work, finding the aspects that are not a zero-sum game, and finding ways that people can live together, living their differences as well as things that have to be overarching commonalities. Please join me in thanking our panel, and then we'll have lunch.